Any mention for understood matter? Any mention for understood matter? From the main list, item number 1.
Yes.
May I please, Your Lordship? My Lord, on 22nd November, when this matter appeared last, the submission was forwarded by the Council of Patricia Knoxage to the effect that the land documents are in the possession of the inquiry officer, my Lord. My Lord, that is, I feel that's not a correct statement because it is not with the inquiry officer. The entire thing has been forwarded to the RG, my Lord. And with the permission of RG, along with the RG and the staffs, my Lord, I have checked all the documents, my Lord. I could not find all these 4 land documents in the papers forwarded, my Lord.
There is submission that title deeds are in the possession of the inquiry officer. Where are
Yes,
the
my
title
Lord.
deeds? Where are the title deeds?
It's not in the. We could not find, my Lord. It is not there.
Very well.
My Lord, in fact, my Lord,
Who appears for that Knoxage?
I am appearing, Your Lordships. This has been, my Lord, during the course of the inquiry, my Lord, this has been taken over. And in fact, my Lord, till date, my Lord, this property is intact.
Where are the title deeds?
Title deeds, my Lord, in course of the inquiry, this has been taken over from me, Your Lordships.
Who are you appearing for?
My Lord, I have been appointed amicus in this matter to assist the court, my Lord.
When title deeds are taken over, there is some kind of receipt which is given.
No, my Lord, that is the unfortunate.
All right.
It is the unfortunate.
Come back to court. From tomorrow you go straight to jail from here. Since it is evident that
Lordship, in that case, my Lord, may I pray?
Patricia Knoxage has made a false statement in court to the effect that the title deeds pertaining to the parcels of land are in the custody and possession of the inquiry officer.
My Lord, so far the
And
offence,
no evidence
Lordship,
of such deposit can be demonstrated. Patricia Knoxage will be present in court, in terms of the undertaking furnished on November 20, 2022 at first sitting on December 15, 2022 for appropriate action, for immediate appropriate action to be taken against her in accordance with law. Produce receipt on the street. Yes, who are you appearing for?
I'm appealing for respondent number 2, original landowner. What has happened is that the original landowner also filed the SLP before the Honorable Apex Court.
Can't understand what you're saying, sir.
And my Lord,
Can't understand what you're saying.
my Lord, the original petitioner, the landowner, respondent number 4 and respondent number 2, has also filed the SLP before the Honorable Apex Court.
Maybe.
Challenging the acquisition, my Lord. And when disposing of the petition filed by Belinda Lapang, there was an observation that by that time I have received 2 crores 40 lakhs. So with that, my Lord, the Honorable Apex Court observed that that amount was overseen by the Deputy Commissioner, my Lord. By that time, my Lord, we have not utilized it.
Maybe we'll see. Let her
Allow
come.
us to file a short affidavit explaining that situation.
Fine. Whenever at your convenience.
Right.
Let this appear on 15. Let us first deal with this
Yes.
lady.
Fine.
Or on the next matter, please.
Item number 2.
Yes. The repair to NH6 has not yet been completed.
My Lord, on behalf of the National Highway, my Lord, the authorities could not complete it because in between there was some blockade and impediments which are coming up. So, my lord,
When, where?
in NH 6
Yes.
stretch, my lord, we have got a status report, my lord, which shows that most of the part is done, my lord. May I? Could not get color photograph, my lord.
And 2 kilometers is from where to where?
My lord, length of 70 kilometers out of 102 kilometers
Maybe
from the
102
entire stretch, my lord.
And 2 kilometers is where to where?
Starting from Joy to Ratachara, my lord.
Joy to?
Ratachara, 173, passing through Clariat, Umslong and village Malido. It was in the affidavit filed earlier, my lord. We have
Extra copies. Photographs.
What about the stretch, the Joy bypass? Who is responsible for that? Instead of going straight, if you're coming from Clariat, instead of going straight to Joy, there's a Joy bypass, you turn right.
yes, my lord.
That is the worst stretch of the road.
Perhaps, my lord, we'll have to need some more time, my lord. Through the PWD also, we'll have to work in.
You had originally said November 15, then you said that no.
For the national highway.
That is December 15, we made it December 15, today we are on 13th December and you say nothing is done.
As far as my information, lordship, I have been informed that, my lord, no progressive work has been carried out, my lordship.
My lord, it will be a continuous process and we are trying to complete the full stretch, my lord. And
And then in a month you say rains are back.
No, my lord, by January 10th or 15th, my lord, we anticipate that we will be completing this NH under the National Highway Authorities, my lord. We will anyhow will complete the entire stretch.
Including the bypass.
My lord, for the bypass stretch, my lord, I believe it will be also under the PWD. I'll talk to the officers and we'll get it done on the
See,
bypass.
if it is under the PWD, then the PWD should do it.
Yes, my lord.
If it is under your supervision, then you should do
We'll
it.
do it, my lord.
Because that bypass is terrible and most
My
of the heavy vehicles,
My lord.
they take the bypass, they don't go through Jawai.
Bypass.
You know, when you're going from Shillong to Jawai,
Yes, my lord.
you turn left before going to Jawai. And if you're coming from Clariat to Jawai, you turn right before coming to Jawai.
Yes, my lord.
That stretch,
We will definitely take care of that.
the NHAI is represented, the NHAI submits that substantial repair work on the NH6 has been completed, but at some places, the repair work along with the usual maintenance is are continuing. Full stop. Paragraph, National Highways Authority of India. Paragraph. According to NHAI, the entire stretch of 102.255 km from Jawai to Rajachera.
Yes, my lord.
What Chera?
Ratachera.
Ratachera would be repaired and restored by January 10, 2023, at the latest. Full stop. Paragraph. There is also the matter of the Jawai bypass, which is in a terrible state. Vehicles going to Clariot and beyond, from vehicles coming from the Shillong side and going to Clariot and beyond, particularly goods vehicles, use the bypass. Similarly, Shillong or Guwahati bound vehicles coming from the Silchar side and not needing to go to Jawai use the bypass. Full stop. Such bypass is in a deplorable condition and requires immediate repair. Paragraph. NHAI says that, now counsel for NHAI submits that it is not immediately clear whether the responsibility for repairing the bypass is of the NHAI or of the state PWD. Full stop. Paragraph. The bypass requires immediate repair work for it to be usable. Full stop. Whether it is the NHAI or the state PWD, the appropriate organization should take immediate steps in such regard, such that the repair work is completed by the middle of January 2023. Paragraph. The petitioner will forward a copy of this order to the state PWD for bracket roads, PWD units and roads, for immediate appropriate action, in the event it is the PWD bracket roads which is responsible for the relevant stretch of road. Yes.
Lordship, in terms of order dated 3/11/2022,
Yes.
the state was supposed to file a time-bound Lordship road map. That has also not been placed, if I can.
My Lord, for the state, Mr. K. Khan was leading me in this case. Of course, my Lord, a bar chart has been prepared by the state, my Lord, but the bar chart does not indicate the areas of the work, my Lord. So I need some more time to prepare a thorough bar chart
The
indicating.
matter will appear immediately after the vacation, and the state should file a status report to indicate the state of the roads and the extent of repair work undertaken by PWD roads to repair and maintain the same. Yes.
My Lord, should it be, my Lord, district-wise, my Lord, so that we can indicate, the state can indicate the districts, which portions?
You do it, that will be much better.
Better, my Lord.
We
We'll
are
try
not.
to- Because the bar chart which they have given, my Lord, it is very cryptic and it does not speak the area of work where they have carried out, my Lord, so I am not placing it.
Very well.
Item number 3.
May it please your Lordship.
Yes, madam.
Lordship, I am appearing for the respondent here.
Yes.
But only I got the instruction to appear verbally, Lordship, not yet received the wakalatnama because the respondent had received the appeal copy only yesterday night, Lordship, via email. So, Lordship, I need some time, Lordship.
Very well, the respondent is represented. And what is your name, madam?
M. Bordoloi, Lordship.
M. Bordoloi.
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 And Ms. M. Bordoloi undertakes to file the wakalatnama for the respondent, full stop, let the matter appear a week after the vacation, full stop. The wakalatnama should be filed by then, full stop. Since this is an appeal, no further pleadings need be filed for the matter to be taken up for hearing. Yes.
But only one aspect, my lord. The contempt proceedings are pending before the learned single judge, my lord. If that can be kept in abeyance till the next date, my lord.
Very well. It will be open to the appellants to seek an adjournment of the contempt proceedings before the single bench.
Deeply.
Item number 4.
Bring constitution.
This is your Lordship. Lordship, in terms of the last order dated 7/12, your Lordship, I have obtained instruction, your Lordship. The instruction is that no other candidates from outside Dadinkiri had applied.
Sorry, no?
No other candidates from outside Dadinkiri, your Lordship, because the selection process involved in this petition is Dadinkiri. So no candidate from outside Dadinkiri had applied, your Lordship.
Where is the advertisement?
The advertisement,
It pays 98, my lord.
Name of the post is?
assistant teacher, your Lordship.
Has to be 89. Oh, Garo 111.
My lord.
Lordship.
202 posts were advertised, my lord. There was no stipulation in the advertisement that only the residents of
There's
Dadinkiri.
nothing there. Nothing in the advertisement about residency.
Lordship, it's true, but no candidate from outside Dadinkiri had applied, your Lordship. No such application had been received, your Lordship.
Is it a writ petition or an appeal?
This is a appeal, your Lordship.
Appeal.
Your Lordship, yes.
So was an affidavit filed by them?
No, my lord.
No, your Lordship.
There was no affidavit filed by the state, my lord. Only on the submission, at the order stage itself, my lord, only on the submission of the government council, the matter was dismissed, my lord.
No, your Lordship. Lordship, if Lordship is pleased to kindly come to page 121, your Lordship.
121.
Lordship, yes, at paragraph 6 of the appeal judgment. As submitted by the learned G, admitted by the
Yes, how can your case be believed?
Lordship.
My lord, why I'm saying, my lord, if Lordship kindly turns to page 103, the wording of page 105, my lord, 105. My lord, it says, my lord, in inviting a reference to the letter quoted above on the subject, I am directed to inform that the government agreed to the proposal to allow the candidates from Turao to apply for the vacant post of assistant teacher. That means they are not allowed earlier, my lord. And not allowed was given effect in the sense that their applications were not even received, my lord.
So it appears that you did not apply, but you are trying to create a situation after seeing the 1st March 2022. And the judges clearly said that, what do I go by?
My lord, our case, my lord, if they extend on 1st of March, my lord, the closing date of advertisement was 18th of January, my lord. How this extension is given effect to, my lord, by the government? This comes on 1st of March. In terms of this letter of 1st March, my lord, they have to reopen or extend the period of submission of the application, my lord. And my lord, there are 202 posts, of course reduced to 159 posts, my lord. So why they want to restrict the applicants, my lord? The fairness requires, my lord, more and more participants should be there in the...
Has the process been completed?
No, my lord. Not yet been completed.
Lordship, kindly come to page 103, Your Lordship. The cut-off date for receiving the application, Your Lordship, that is 18 Jan 2022, Your Lordship. And the letter which which has been referred, Your Lordship, that is 1st March 2022, Your Lordship, that has been issued much after the cut-off date for receiving the application, Your Lordship. Lordship, kindly come to page 105 again, Your Lordship. There is a reference of the letter 17/2/2022, Your Lordship.
What is the use of issuing a notification in March when the last date for receiving application?
In my humble and respectful submission, Your Lordship, this letter of 1st March 2022, Your Lordship, will remain in prospective operation, Your Lordship. It will be applicable prospectively, Your Lordship.
But in the application, in the advertisement itself, you did not make any condition as to residency.
It's true, Your Lordship. It's true, Your Lordship. But the fact remains, Your Lordship, as per the instruction, we have never
What is the stage? What is the stage of the recruitment process?
My lord, in another proceedings, the recruitment process was stayed by the head single judge, my lord, in a different writ petition. And that writ petition was ultimately disposed of only in the month of October, my lord.
Lordship, I am instructed that now it's only a result will be declared and a successful candidate, Your Lordship, will be called for personal interview and all.
So, interview is still left.
For personal, Lordship, the result will be declared and the personal interview, successful candidate will be called for personal interview, Your Lordship.
You have to allow non-Dalungri people to apply, then you have to conduct the test again. This we will not do.
Lordship, but the letter dated 1st March, Your Lordship, that for the future selection, Your Lordship.
If it is for future, then why did your advertisement not restricted to Dalungri residents?
It's there, Lordship, yes. It is, that is not, has not been specified that only for the resident of the Dalungri, it's true, Your Lordship.
And the reference is 17th of?
17/2, Your Lordship.
So where is that letter?
Lordship, that has not been enclosed in the...
You have it. You have it, show it to us. Who wrote that, who made the reference?
This is by the Education Department, Your Lordship.
Yes. The Education Department was also confused.
This is Special Officer, Education Department.
He is referring to this letter. So this letter is from the Director of School Education.
Lordship, we will have a copy of this letter, Your Lordship. If this matter can come again on Friday, Your Lordship.
Why Friday? Tomorrow? This kind of matter cannot wait.
Lordship, yes. Then tomorrow, Your Lordship.
At the request of the state, let the matter appear on December 14. Paragraph, since it appears that the recruitment process pertaining to assistant teachers in Dadengre in terms of an advertisement of
December 2,
2021 and has not yet been completed, no further steps pertaining to the recruitment process will be taken without the express leave of this court. Yes.
Item number 5.
May it please your lordship.
Yes.
Consequence to last order of this honorable court, we have carried out the process from the side of the executive committee as well as from the side of the same Million. Then we also had the same Million had a general meeting of the particular village, Contempt Golfing in particular, from where the writ petitioner is hailing. And there we had a meeting. It's since I was out of station, your lordship, this reached late in the night. I could not translate into English. So there is a report, there is a resolution that the women folk are taking part in the, in the Darbar proceeding, as well as for election of a headman.
Very good. The district council says that there has been a positive development in the matter pertaining to the participation of women, both in the election process and being entitled to stand
No, not that part.
in the election process. Full stop. The district council seeks some time to file a report on the on such aspect. Paragraph. Let the matter appear immediately after the vacation, by which time a copy of the report should also be filed.
Much better.
Not a copy, the report should also be filed. Yes.
Item number 6.
Authorized.
What is the item now?
Who prepared the paper book? Who prepared the paper?
Department, my lord. I only had it bound up.
Come to page 127A. One 127A is a repeat of 127.
Yes, your lordship.
Come to 128. 128 has been repeated at 129.
Yes.
Where is internal page 6 of the judgment containing paragraph 11?
Oh. One, two, three, four, five, six. What is that? This one.
Repetition. 12, 13, 14, 15, 17, 15, 16, 16, 15, 16. No, 16 is not there. 16 is not there.
Not there.
16 is not there, Your Lordship.
Page 6. Internal page 6.
Paragraph 16 also is not there, Your Lordship.
Paragraph 16 is not there.
Lordship, if
11
Lordship
is not there.
If Lordship is pleased to kindly come to page 133.
Yes.
Then Lordship will kindly turn to 134. Straight away from paragraph 15, internal paragraph 15 of the interim judgment, straight away to paragraph 17, Your Lordship. Oh, no, so I'm sorry, Your Lordship. It is there, Your Lordship. Paragraph 16.
In the seal.
In the seal, Your Lordship. I'm sorry, Your Lordship. It is there.
Do we have the copy of the judgment elsewhere in the papers?
Well, in the memo of appeal.
See if it is completely there.
Just a minute.
It's there.
110. Page
Paragraph 11 is there.
6 is there, page 110.
Yeah. Paragraph 10. 11 where? Yes. 11
In the
is
seal.
11 is there, Madam.
11 is there.
110.
14, 16, 16, 17, 18, 20, 21.
Now, please come to the beginning of the judgment. We'll look at it from the, I've marked it in the other one, but we'll look at it over here. Please come to page 4. Paragraph 7 indicates the list of documents.
Yes, Madam.
There is nothing other than the FIR, postmortem report, seizure list and inquest report. Now, where is the reference to 164 in the body of the judgment?
Yes. Now, starting at page 154.
154.
154 of the judge of.
Yes, yes. On the bottom page, I couldn't say because that. No, 154.
Paragraph 40.
No, paragraph 43.
Paragraph 43.
Which one?
Paragraph 46.
Not exceeded.
It is written, not exhibited.
Not exhibited, yes.
How could this happen? Not exhibited by the prosecution?
By the prosecution, Your Lordship.
How could that be referred to?
Lordship, the public prosecutor there ought to have exhibited, Your Lordship.
And please also show us that what was passed on under 207.
Pardon, Your Lordship?
What papers were forwarded to the accused under 207?
Order sheet. That will have to be seen from the order sheet, Your Lordship.
Yes.
That only from the order sheet.
Tell us from the other sheet.
Then we will have to.
Now I should have handed it over.
No, just see what is there, share it with him, he doesn't have a copy.
This starts from here, when it is transferred to.
Just a minute.
Yes.
Now read it out, please.
Lordship, it say like this. 24/7/2013 case withdrawn to my file and transferred to the Court of District and Session JY for dispersal. Then next, Your Lordship, present so and so, session case number and so. Then 2/8/2013 notification number so and so, 18 July 2013. Peruse case is pending for CC. Register the case and for CC. Record put up. Then 26/8/2013 record put up. Prosecution is present by Lanet PP so accused person so and so. Defense counsel is preoccupied in district court. The last pending for CC and submitted by cannot be allowed to go on.
The charge is framed on that date.
Then
So what documents were made over?
Lordship, as per 07, Your Lordship. The short sheet, Your Lordship, as per 207, the requirement is the police report, that means the short sheet, Your Lordship, the first information report, and the statement recorded, Your Lordship, under 161, so also under 164.
So that is not given?
Lordship,
Were 161 statements given?
Lordship, yes, certainly, Your Lordship.
Where is it recorded? What is given under 207? Somewhere it will be recorded what has passed under 207.
The yellow file, yellow. Myself is.
Who will have? See the IO's case diary, if it is recorded what papers have been supplied.
27 not.
It's from here.
My Honourable Lordship allows me, may I say something in this regard? My Lord, I was telling your Lordship that the procedure which was being adopted here was the procedure in the old Act.
Assam.
No, in the old Act of CRPC, 1898. Now there is a committal proceedings. Now here what happened was that argument before consideration charge before the magistrate. Then the matter is committed to the court. Now that was dispensed with, 27 dispensed with, straightaway charge framed on the day the session judge received the application.
Then the accused will always be in a disadvantaged position.
Yes, Madam.
Inherent disadvantage.
Yes. And they have admitted it once it was not given to us.
No, there's nothing.
And 164 was only of PW 1 and 2.
Yes, and 5.
PW 5 also.
Yes.
5 meaning the FIR maker.
No, that's four. So the other person must.
5 is the IO.
No.
First IO.
No, 6.
PW5, Your Lordship.
PW5 is one of the 3 persons who were there who did not say anything about witnessing the incident.
During the course,
what is the name of the PW5?
Deling Tamang. He was one of the 3 persons.
He said, I don't know anything. I don't.
That is why, and he was not declared hostile.
he turned hostile, Your Lordship.
No, he did not. You never declared him hostile.
He turned hostile, but unfortunately, the prosecutor before the trial court did not declare him hostile.
Then the benefit of that goes to the accused.
He ought to have
your witness
Lordship is true.
comes and says something which is against your case. Unless you declare him hostile, you also carry him with you.
That should have been done, Your Lordship, by the learned public prosecutor. Unfortunately, it was not done, Your Lordship. It was not done, Your Lordship. It appears from
it was not done.
It was not done.
His 164 was not on record. Then what is the basis of conviction?
Lordship, because the evidence of PW 1 and 2, Your Lordship, as I have submitted, Your Lordship, their evidence are direct evidence, Your Lordship. And during the course of trial, Your Lordship, even during the course of cross-examination by the defense counsel, these were never demolished, Your Lordship.
Anyway, what we will do is,
Lordship,
we will send it for retrial from the stage of, from what stage? From the stage of recording evidence.
Now, there are 2 things here. Once Your Lordship speaks about, then Your Lordship keeps the charge. Now, the charge was of 10th, conviction is of the 9th. So that is covered up. But after 14 years, whether Your Lordship will come to that stage or not. Because it's 2008 incident February. With due respect, Your Lordship has seen the charge, seen the conviction, seen the...
No, the PW1 says, PW2 does not record the date.
Any date.
PW1 says it is on 9th.
Yes.
And PW, the FIR maker also indicates...
No, 10th.
No.
He speaks about 10th.
He speaks about 10th.
The FIR maker. Now, who is the FIR maker? The IO says the sister of the deceased made the FIR.
And actually it is the brother.
The brother. That is on record?
One minute, please.
Sorry.
Now, there are 2 parts to it. PW6, from 10th onwards, was the IO. He ceased to be IO on the 27th of March. PW7 steps into his shoes. Thereafter, what happened was, on the 26th of May, one PP, one gentleman by the name of Pirate something, PP, he was arrested. He was taken into police custody for 8 days, saying that he was the person responsible for the death of this person. Now, all of a sudden, my lord, on the 9th of June 2008, these 2, 1 and 2 were examined.
That, Mr. Mukherjee, we take it to be a red herring.
Please, yes.
That will not affect us.
No, I appreciate. But the only thing is what
affects us is who are these persons who have been accused and what is their connection. There is some basis to it.
True, but that's what I'm saying. You're actually sending it for retrial. So it starts from which stage? That is what I was trying to.
That's what we are trying to.
I'm trying to impress upon your lordships. Now I leave it to your lordships too, because I don't want either we get the benefit or the prosecution get the benefit by your lordships order. This is what I'm trying to say. But when release me on bail, I was on bail for 14 years.
We will after some time.
Then keeps it in the order itself.
We will do it. We will ask them to start the thing from a particular date. We will require evidence of PW 1 and 2 to be completed. And then within a particular time and immediately thereafter bail.
Right.
Lordship, may I submit, Your Lordship? Let it be from the stage of recording of evidence, Your Lordship.
That is what I will say.
Lordship, yes.
And we'll attribute it to you now. That you want it from the stage of recording of evidence. So you will take the responsibility. It's purely up to you. We have asked a question and you say that from recording evidence.
Lordship, yes. May I submit further, Your Lordship?
Yes.
Because Lordship saying the responsibility on me, Your Lordship, because there is a prosecutor to conduct the case before the session.
You have to educate your prosecutors, sir. We cannot help you in that. We cannot help you in that. And we are looking at liberty. We suspect that he has done it. But we can't go by suspicion. After all, it's his liberty at stake.
Lordship.
Consider from the time of framing charges.
Well, then the whole thing becomes de novo.
De novo.
Only one request.
Yes.
The charge which my Lord Justice Bedagno has told the Lordship, it has to start from the 207 papers. So the 7 papers which is there, let it remain, nothing new to us.
What schedule will do is, within 2 weeks from date,
Yes, Lord.
the entire 207 papers will be given to you and recorded as to what papers have been handed over to you.
So, my Lord, the whole judgment, Your Lordship will set aside.
Yes.
The papers given are only 4.
Yes, we are setting aside the judgment and we are asking for a retrial, and we say within 2 weeks, 207 papers will be given to you and charges will be framed thereupon after you receive the 207 papers, within a week thereafter, and recording of evidence will start within 2 weeks thereafter.
So 5 weeks in all.
5 weeks in all.
After that is finished,
by which 1 and 2 will be
released on bail.
By which 1 and 2 evidence should be completed. Immediately after conclusion of 1 and 2, you will be released on bail.
I am grateful, my Lord.
Okay. In course of this appeal, several anomalies have come to the fore which indicate that the appellant may have been seriously prejudiced in course of the trial for want of due diligence on the part of the prosecution. Full stop. Paragraph. The matter pertains to an incident of February 2008. Here again, the exact date of the incident cannot be indicated with any degree of certainty, on the basis of the material now available. Full stop. The long and short of the case is that a gentleman met an unnatural death and his body was found one morning in February 2008 outside the office of the Deputy Commissioner in Jawai. Full stop. Paragraph. There appear to be contradictions even as to the FIR maker. Full stop. Though PW 4, a brother of the deceased has been examined and such person claimed to have lodged the FIR which was marked as Exhibit 2 and also identified his signature which was marked as Exhibit 2 bracket 1, the second investigating officer maintained in course of his deposition that it was a sister of the deceased who had lodged the FIR. Full stop. Paragraph. PW1 and PW2, comma, in course of their deposition at the trial, comma, claim to have been eyewitnesses, full stop. PW1 indicates the date of the incident to be February 9, 2008, comma, though PW2 does not indicate any date. Full stop. In the impugned judgment of conviction of January 19, 2022, 2022?
Yes. No. 22.
22?
Yes.
Of January 19, 2022, paragraph 7 lists the documents that were exhibited by the prosecution. Full stop. The documents referred to are the FIR of February 10, 2008, comma, a postmortem report of February 10, 2008, a season list, and an inquest report, and no other papers. Full stop. Yet, comma, the judgment copiously refers to statements rendered by PW1 and PW2, comma, apparently under section 164 of the Code of Criminal Procedure 1973. Full stop. Paragraph. The appellant claims that no copies of such statements were made over to the appellant. Full stop. Indeed, comma, the appellant claims that no documents were made over to the appellant in terms of section 207 of the code, comma, though the practice here at the relevant time was as per the old code of 1898. Full stop. Paragraph. Whatever may have been the practice, comma, the object of the exercise is to ensure a degree of procedural fairness so that a person may be aware of what he is charged with and what material is produced against him to bring home the charges. Full stop. In the absence of the purported statements recorded under section 164 of the code being exhibited and in the absence of such statements being made over to the accused, comma, no reliance thereon could have been placed by the trial court. Full stop. Paragraph. It would be unwise to divorce the reasoning in the judgment of in the impugned judgment of conviction from the impression that the purported statements under section 164 of the code may have created on the trial judge, and as to how the rest of the evidence was seen by the trial judge in the light of such statements. Full stop. Paragraph. Further, comma, the examination of the appellant under section 313 of the code leaves a lot to be desired. Full stop. In course of such examination, comma, it is the duty of the trial court to explain the material against the accused, to afford the accused an opportunity to explain his conduct in the light of such material, against the backdrop of such material. Full stop. The trial court's obligation in such regard is not ministerial or clerical. By merely asking the accused to respond to the deposition of a particular witness, even if the entire deposition is read out. Full stop. The duty in such regard is to glean out the essence of any statement or deposition and elicit, so that it may elicit an appropriate response from the accused. Full stop. In short, comma, the accused must be made to understand the impact of a statement or evidence for the accused to consider whether the same ought to be dealt with or replied to. Full stop. Paragraph. The manner in which such exercise was conducted in this case was not either in the spirit of the provision or in the interest of justice as far as the accused was concerned. Full stop. Paragraph. On an overall appreciation of the matter, comma, there appeared to have been several anomalies that led to a miscarriage of justice in the appellant herein, either not having due opportunity to deal with certain statements or not being explained the purports of the other material against him. Full stop. Paragraph. Accordingly, comma, the impugned judgment of conviction and the consequent sentence stand set aside. Judgment of conviction, consequent sentence of, those two dates have to be given. Stand set aside. Full stop. So that neither the prosecution nor the appellant herein are prejudiced, comma, the greater details of the matter have not been gone into. Full stop. A a retrial is called for, from the stage of the framing of charges upon all documents to be relied upon by the prosecution against the appellant herein to be made over to the appellant within a period of a fortnight from date. Full stop. Paragraph, since the matter is of the year 2008, a tentative schedule is drawn up for the conduct of the trial, which should be adhered to, full stop, within a fortnight from date, as indicated above, all papers and documents to be relied upon by the prosecution against the appellant should be made over to the appellant upon duly recording the same, full stop. The charges be framed afresh within a week of the receipt of such papers, full stop. The trial will commence within a week thereafter, and within 2 weeks of the commencement of the trial, the oral evidence of original PW1 and original PW2 should be completed, full stop. Upon the completion of the recording of the evidence of such witnesses, the appellant herein will be entitled to be released on bail on such conditions as the trial court may deem appropriate, full stop. Paragraph, the trial court will endeavor to complete the trial within 8 weeks after the completion of the recording, after the completion of the recording of the evidence of PW1 and PW2, full stop. The appellant will not be entitled to seek any adjournment, the prosecution should make every endeavor to be represented on the dates set by the trial court, and the trial court may take up the matter on a daily basis so as to adhere to the schedule indicated herein. Full stop. Paragraph. The observations here, which were necessary for the purpose of remanding the matter for a fresh trial, will not prejudice either the prosecution or the appellant herein in course of the fresh trial. Full stop. Criminal appeal number 4 of 2022 is disposed of.
Not only one, Graceful, another accused was there. She was acquitted.
Sorry?
Graceful, a lady, she was one of the accused. She was acquitted by this judgment.
When we say set aside,
yes,
to the extent it concerns the appellant herein.
Yes.
Lordship, the next case
Same.
is appellant in the same judgment, Your Lordship. The next case, item number 8.
Next case, who's the appellant?
Common Raban, Your Lordship.
So 7 years, 201.
He was convicted and sentenced under 2 years.
Coming. The person who came and opened at midnight.
Yes.
And took you for dinner in the Maruti.
Yes, my Lordship.
Then Lordship, another aspect of the matter is that since the LCR has been called, Your Lordship, this will be returned along with the copy of the judgment, Your Lordship.
Paragraph, this order will also govern criminal appeal number so-and-so pertaining to coming whatever alias.
Criminal appeal 6, Your Lordship.
Criminal appeal 6, give the name of the appellant over there also.
Item number 8.
Then last, the lower court records which are available in this court should be returned to the trial court in court by December 15, 2022.
Along with a copy of the judgment, Your Lordship.
But automatically so.
Along with copy of which judgment?
Your Lordship judgment.
That's available on the net. That will be available at 4 o'clock on the net.
I'm grateful to Your Lordship, really grateful.
Done?
Yes,
He will come back. He will come only 5 weeks from today.